And I want to thank everyone for attending this webinar this morning on the wage and hour update for California employers. Let me introduce Sherry Shavit just for a couple of items. We are recording this webinar, and we will have a copy of it available to email to you and also on our website and our blog. And if you have any questions during the webinar, if you just hit the chat button in the bottom of your screen and type in a question, Sherry and I will be able to hear you. Let me just give a quick introduction. I met Sherry through PIRA, the profession, actually the LA chapter of the Society of Resource Management. Sherry's a partner in the law firm of Tharp and Howell. She represents employers of all sizes on a wide variety of matters, including wage and hour, medical disability leave, discrimination, harassment, wrongful termination, updates handbooks, does policies, procedures, anti-harassment training, things of that nature. She's one of the employment lawyers that our Really Great Employee Benefits really like. We think that she's down to earth, understands businesses, and works well with our clients. So on that note, Sherry, I will turn it over to you.
Thank you so much, Barry. Hopefully everybody can hear me. Good morning, everyone, and thanks for joining me today to talk about the latest and greatest updates to California's employment laws. This morning I'll be focusing primarily on wage and hour issues such as minimum wage, overtime, and paid sick leave, but I will be touching on some other topics as well that will impact employers outside of the wage and hour arena, such as joint employment and arbitration agreements. We'll talk about laws that have already gone into effect, others that are scheduled to go into effect in December or January, and others that are right now in sort of a wait-and-see mode. It's actually really great that Barry gave me the opportunity to speak at this particular time because it's a particularly volatile period of time. We are at the end of California's 2-year legislation cycle. So right now there's a flurry of activity going on. The legislature has passed all the laws that they want to enact, and we're waiting to see which ones Governor Brown agrees to or vetoes. And also on the federal level, since we're heading into or already in election season, the state agencies right now are trying to get all their regulations done during this lame duck session to try and accomplish President Obama's objectives. So there's a lot going on. There's a lot on the horizon, and it's really quite an exciting time for people like me who do employment law. But before I get into the nitty-gritty of what we're going to talk about today, since I am a lawyer, I of course feel compelled to give you a legal disclosure. This webinar is intended to be for informational purposes only for you and does not constitute legal advice. Unless you already have a relationship with my firm, we don't have an attorney-client relationship. And this webinar does not and is not intended to create such a relationship. So now that I've told you that we all have no relationship whatsoever, I actually do want to get to know you and your company. It will be helpful for me as we go through this webinar to know what types of industries you're in and how large your companies are, so I know what to highlight as we go through. So if you could just take a moment and in the chat box, just type in the type of industry your company is in, like retail or manufacturing, and approximately how many employees your company has and whether your company has any federal contracts. And if you guys could, I'm going to give you guys a moment to do that so I can see what comes up. Looks like I'm getting some responses, and we're getting all different kinds of companies, which is really exciting. And so that's good because some of these laws, a lot of them will apply to everyone, some to no one, some to some people. We've got some large companies, with over 100 employees, and then we have some small ones with like of just 4 to 10 employees, and that's great. Okay, so you can keep typing and giving me your information as we go, and we can focus on it. Let's see, do we have any federal contracts? We might have 1 or 2 here. Okay, so let me keep going then. So although I can't see you guys, I am hoping that this will be an interactive session. I will be asking you some questions throughout the webinar, and as Barry said earlier, if you have any questions, feel free to send them in the chat box, and I will try to get to all of them, time permitting. Some of the subjects that we're going to talk about today could be really full webinars on their own, so I'm not going to go into full detail on everything, but hopefully we'll be able to answer a lot of your questions today. So let's get started with something that at first blush seems easy, but can get complicated pretty quickly. And we're going to talk about minimum wages. As I'm sure you know, California has enacted minimum wage increases that eventually will go up to $15 an hour. And how quickly the minimum wage goes up depends on how large your company is. And since we do have all different sizes of employers here, this is all going to be important to everybody. So for instance, if you are an employer with 25 or less employees, the minimum wage will go up for your company up to $15 an hour by the year 2023, whereas it will go a little bit faster if you have 26 or more employees, and you will hit $15 an hour by 2022. So you might be saying to yourself at this point, really, I'm carving out an hour of my time so you can tell me this? Well, let's add another layer of complexity to the minimum wage issue. So California has its own idea as to what minimum wages should be and how quickly those goals should be reached. But there are many municipalities within California that have their own ideas. So for instance, employers who have employees working in Los Angeles, the minimum wage will ultimately get to $15 per hour, but at a faster pace. So while large employers in the rest of the state have to pay $15 by 2022 and small employers in 2023, in Los Angeles, large employers will have to pay $15 2 years earlier by 2020 and small employers by 2021. Complicated yet? Let's keep going. So not just Los Angeles, but there are a whole bunch of other municipalities in California that have implemented their own minimum wage increases. Cities such as Pasadena, San Diego, San Francisco, Santa Monica, and there's a whole list listed up here in the PowerPoint. So effectively, if you have employees sort of scattered around the state, especially if you're like a sales company or something and you have salespeople in different territories across the state, if you pay the minimum wage, you're going to be paying a lot of different people a lot of different wage rates just to do the same job. And then on top of it, if you're a federal contractor, because there are some people here who do, not in California, but outside of California where the minimum wage is lower in certain states, the new minimum wage for federal contractors starting January 1 is going to be $10.20. So the minimum wage increase, though, it doesn't just affect your low-wage earners. There are other things that you need to keep in mind as the minimum wage starts to increase. So for instance, for your exempt employees, as you know, one of the tests that you have is that you have to be paying your exempt employees, at least for most exemptions, 2 times the minimum wage. So as the minimum wage goes up, the amount of the salary that you need to be paying your exempt employees is also going to be increasing. So you have to look not only at your low-wage earners, but you're also going to have to look at those exempt employees that you have that are around the cusp of that 2 times minimum wage and whether you're going to need to increase those salaries as well. I didn't ask this, but if there are anybody out there that has collective bargaining agreements, there are certain exemptions to the certain wage laws, the overtime law and the meal period law, for companies that have collective bargaining agreements that address those issues. However, those labor code provisions require that the employees be paid at least 30% over the minimum wage. So as the minimum wage goes up, the exemptions are also going to increase, and so you're going to need to take a look at those collective bargaining agreements, some of which are negotiated for several years out in terms of what the wage rates are going to be, and make sure that it's going to continue to stay in line not only with California's minimum wage, but also the minimum wages of your municipalities where your employees are working. And another thing to keep in mind too is that the wage posters that you have, there are new ones that are going to need to be put up. In Los Angeles, they've specifically required that you have one for Los Angeles with the new minimum wage information on it. And also on the federal side, there's new minimum wage and polygraph posters that need to be put up. So you want to make sure that you're doing that as well. Now, we touched a little bit on exemptions in terms of the minimum wage issue, but of course that gets even more complicated, possibly. We have the Federal Department of Labor that has proposed new regulations to increase the requirements for exemptions. And they are supposed to go into effect on December 1, 2016. Now, I've put a question mark here because right now there are several efforts to try and stop these regulations from going into effect. There are some bills kind of going through Congress right now, both on the Senate and on the representative side, to try and defeat these regulations. And just recently there was a lawsuit filed in Texas by 21 states and over 50 business groups, including SHRM, to try and stop these regulations from going into place. We don't know right now what effect those efforts are going to have and whether anything will be stopped as of December 1. But just in case it doesn't get stopped, we'll go ahead and cover the topic here today. So the new minimum requirements that are being proposed is that the minimum salary for exempt employees is going to be increased to $47,476, or $913 per week. This is a pretty significant raise for most of the country. Here it's going to affect hours for a few years, but since we have the increase in the minimum wage going on, in a couple years we're going to catch up to that anyways, and it won't be such an issue. Now, they also are going to be increasing what they call the highly compensated employee exemption, which is increasing to $134,004. And then these thresholds. I'm sorry. Did we lose connection with everybody? I'm getting a message that there was some audio lost. Okay. Other people can still hear me. Great. Thank you. Okay, so the thresholds are subject to increase every 3 years starting on January 1st, 2020. This is one of the areas that it's possible that this might get stopped with the lawsuit that's going on. There's some people are predicting that might go into effect. And the problem with this issue too is there is so much uncertainty in terms of where things are going to be increasing. So as your companies are preparing budgets and stuff, it's very difficult to be able to predict what your labor costs are going to be if you don't know what the thresholds are going to be. Now, in order to meet these new salary requirements, at least on the federal level, employers are going to be able to also take other compensation into consideration. So for instance, they're going to be able to use non-discretionary bonuses, incentive payments, and commissions that are paid at least quarterly to satisfy up to 10% of the minimum salary threshold. And the other saving grace that the Department of Labor has allowed is if for some reason somebody doesn't make that threshold in a particular quarter, then you can give them a lump sum payment at the end of the quarter to meet that threshold so that they don't lose the exemption. Now this is all on the federal level, so the question is, how does that really affect us here in California? So as I mentioned before, the minimum salary threshold will be higher until we hit $12 an hour. And when you hit $12 an hour, again, will depend on how large your employee base is. So it'll be quicker for the larger employers and a year later for the smaller employers. But then in 2020, again, it's going to depend on what additional threshold is required when the Department of Labor makes its new decision as to what the minimum salary level will be for exempt employees. Now I mentioned above also that the Department of Labor has what's called a highly compensated employee exemption. We do not have that here in California. And so it doesn't matter how much money you pay one of your employees if they don't meet one of the duties tests under the California exemptions, they are not going to be exempt. So you can pay somebody $200,000 a year, but if all they're doing is filing papers, then they are not going to be considered an exempt employee. You also in California, for the California requirements, you cannot apply non-discretionary bonuses, incentive payments towards the minimum salary threshold. So here in California, and it gets a little complicated here, but when it comes to the 2 times the minimum salary test, you cannot use or apply the non-discretionary bonuses and incentive payments. But in order to meet the higher exemption level at the federal level, you can take those into consideration. So there is a possibility of having an employee who meets the minimum salary for California but doesn't meet the minimum salary for federal unless you take into account these bonuses and incentive payments. And that will be okay in California as long as all the other requirements are met. And we have a question from someone asking where you can find a document that helps you understand the California duties test. I'm not aware, I'm sure that there are books out there that talk about the different duties tests. The wage orders themselves list what the duties tests are for the different exemptions. Most of the time it has to do with whether you are primarily doing independent discretion and judgment. And that is sort of loosey-goosey as to what that is. And if you are on the fence as to whether somebody does meet the duties test or not, I would suggest that you talk to your legal counsel about that because it can be kind of confusing as to whether somebody actually does meet one of those duty tests or not. Does anybody have any questions about the new exemption rules? Okay, well if you think of any, feel free to type some in, and I will get to them. Oh, we've got one. What is the current California minimum salary for exempt employees? The current California minimum salary is 2 times the minimum wage. So we're at $10 an hour, and we times that by 2080 times 2, and you get $41,600 is going to be your current one. We have another question here. What if you are in Beverly Hills but some of your employees work in Los Angeles? That's a really good question, and if your employees are actually working in proper Los Angeles, then they are going to be subject to the minimum wage within Los Angeles. So if you're headquartered in San Francisco, but you have a salesperson who is working in Los Angeles, that person is going to be subject to the minimum wage in Los Angeles. Okay, there were a couple of new bills that went through regarding overtime eligibility. There was some on agricultural workers and domestic workers. So AB 1066 eliminates the exemption from the meal and rest breaks and day of rest requirements for agricultural workers, and is going to phase in the regular overtime requirements. Right now, the wage order for the agricultural workers does have an overtime provision, but it is different from most of the other wage orders, and they are now getting rid of that, and they're going to phase in the normal overtime rates for agricultural workers. And then also for the domestic workers, if you may recall, there was a new law that went into effect a little while ago, the Domestic Worker Bill of Rights, requiring that domestic workers also receive overtime. That Bill of Rights was set to expire on January 1, but that has been repealed, and it is going to now stay in place. Okay, so next we're going to talk about the regular rate of pay. And the regular rate of pay, that is the rate that you use to calculate overtime premium. Normally, the regular rate of pay is just however much you pay somebody per hour. And that is what the City of San Gabriel thought. But recently, the Ninth Circuit said, no, that isn't correct. So what happened in the Flores versus City of San Gabriel case is that the City of San Gabriel offers their employees certain benefits, and some of you out there might do this as well. They were offering benefits, but if an employee decided that they did not want to take those benefits, perhaps their spouse gave better benefits or they're able to get something on an individual basis, then they would offer cash to the employees in lieu of those benefits. And they were just getting separate compensation for that. Well, someone named Flores sued the City of San Gabriel for doing this and said, well, wait a minute, I'm getting this extra compensation, but when calculating my overtime rate, that compensation is not being taken into account to determine the overtime rate. And the Ninth Circuit agreed and said that the cash that's being paid in lieu of the benefits does count towards the regular rate of pay that someone is paid for their work. Even though this particular payment was not directly related to the work or how many hours they worked, it was still related to the fact that they were working. And so it had to be taken into account for the overtime. So this was a really good lesson and is a really good prompt for employers to take a look at their compensation policies and make sure that there aren't additional benefits that you may be providing your employees that could possibly need to be taken into account when trying to figure out the overtime rate. So for instance, non-discretionary bonuses, per diem, housing benefits, on-call pay, all those different types of payments actually need to be included when trying to figure out what the overtime rate is. And I actually have an example of one of my clients that got into a sticky situation here. Where they were actually, they had a plan that they thought was an ERISA plan for vacation. And the way that their vacation plan worked is they would not get paid vacation at the time that they took the vacation. Instead, once they hit their anniversary date, they would get paid for that vacation. Now, because it was an ERISA plan, it fell outside of California law, and so they thought everything was fine because you can do that outside of California, and you can also not pay out the vacation when you leave if you don't hit that anniversary date. So we had a very smart plaintiff lawyer, actually, who filed a claim against my client, claiming that, well, wait a minute, this isn't really vacation pay because they're not getting paid at the time that they take vacation. This is actually a retention bonus because they're actually getting paid at the time that they hit their anniversary pay or their anniversary date. And so we never actually got to the merits of this case, but we did get a judge to say, you know, I kind of like that argument, and it is possible that this might be a non-discretionary bonus. And we're actually in the final stages of settling that case right now. So you have to be careful in terms of what types of payments you are making to your employees and whether those could be considered either non-discretionary bonuses or other types of compensation that might need to be taken into consideration when calculating your overtime.
Sherry?
Yes.
I would like to just add one thing regarding the Flores City of San Gabriel item. It said that they were paying cash paid in lieu of benefits, and I just want to let everybody know that the IRS had a ruling in September of 2013, 2013-54, that says employers cannot pay employees money instead of enrolling in the health insurance unless it's handled through payroll taxes, etc. So I just want to make sure that's clarified so that some employers might not get the idea that, hey, why don't we just pay them money not to enroll in health insurance? That is a no-no under the Affordable Care Act.
Yes, that is correct. Thank you, Barry. I appreciate you adding that. And then we have a question as to what happens if the bonus takes place in a pay period after the overtime hours are worked. Do we have to go back and pay additional overtime? The answer is yes. So what happened in the situation with my client, the bonus was getting paid on the anniversary date. So it wasn't when the overtime hours were worked, it was actually later. So what they would have to do is go back and look at how many overtime hours were worked during that year and do a calculation to figure out what additional pay had to be paid with the bonus to compensate for the overtime premium. And it gets a little complicated. The math gets a little complicated. There are some examples that the DLSE gives in their enforcement guidance book that you can use to try and calculate it, or if you're not good with math like me, then you can call your lawyer and have them figure it out, or your tax professional and have them figure it out for you. And then the question also is, what is the time period that you have to go back and calculate? It depends on what type of pay we're talking about. So for instance, again, going back to my example, it was an annual bonus or an annual pay that they call vacation pay, but turned out to be a bonus, or maybe a bonus. It actually wasn't decided. But in that case, you would have to look at all of the overtime that was incurred throughout that entire one-year period and then pay a small premium above that. So in our particular case, each employee really was not entitled to a whole lot of money because it's spread out over the year, and it really depended on how much overtime somebody would work throughout the year. But the additional amount could actually be pretty negligible. But it's cheaper probably to go ahead and pay that out rather than getting sued and having to pay me or another lawyer to have to fight that case for you. Now the good news is there are some payments that do not go into the regular rate of pay. So payments is discretionary bonuses and gifts. So if you give out random Christmas gifts at the end of the year or holiday gifts, those, or just a random, you did a great job, here's a $25 gift card, you don't have to include those types of compensation for your regular rate of pay. You also do not need to include vacation or sick time pay, holiday pay, expense reimbursements, 401k contributions, the actual overtime pay, you don't have to pay overtime over overtime, stock options, and several other different ones. And so there are a lot of payments that you don't have to take into the regular rate of pay. One of the lessons that is also learned from the Flores case is if you don't know whether something is considered part of the regular rate of pay or not, then you should check with your attorney or your counsel. Because what happened in the Flores case is that the city not only didn't include it, but they also never asked whether it should be included. And because they never asked and they never did their due diligence, they had increased penalties as a result. So because under the FLSA, if the violation is willful, you go from a 2-year to a 3-year statute of limitations, and you can be subject to liquidated damages. And so the city of San Gabriel was actually dinged on that and had to pay out a lot more money as a result of not getting advice or counsel to see whether it should be counted as part of the regular rate of pay. So you should always err on the side of caution and talk to your professionals to double check whether you need to include different types of payments into the regular rate of pay. And there's a question here whether travel meal per diem is regular pay. I'm not yes, if you are paying people per diems, then that is compensation that needs to be included in determining overtime rates.
And Sherry, we have another question about gift cards.
Oh yes, sorry, I missed that one. Do you have to take taxes out on the gift card amount? Wow, that's a good question. I've never been asked that. I'm not a tax professional, and so I really can't answer anything when it comes to taxes. I've never seen taxes taken out of a gift card. Barry, I don't know if you know the answer to that question, but I've never seen anyone take taxes out of a gift card.
Yeah, I'm going to do a little research for Debbie on this, but my guess is that if you're giving gift cards, no one's going to know you gave the gift card, so therefore how would anyone ever find out they got it? But legally, they may still have to do that, so I will double check that.
Okay, thanks, Barry. Okay, so now I'm going to move on to another headache for employers that you guys have been wrestling with and continue to wrestle with and may have to wrestle with even more. Is the paid sick leave benefits. So as we know, in California, we have gone to a paid sick leave law that requires you give either 24 hours or 3 days of paid sick leave, or 1 hour for every 30 hours worked for your employees. There's a lot of technical compliance with these paid sick leave laws, and we don't really have time to go into that today. But if you do have questions about it, I'm happy to answer those offline. But that's where we are today in California. Then Los Angeles decided very quickly to provide even more paid sick leave to employees. And in June of 2016, they passed an ordinance that by July 1, 2016, all employers have to provide at least 48 hours of paid sick leave per year, or 1 hour for every 30 hours worked, just like in California. And you must have to carry over at least 72 hours in Los Angeles. For California, there is no requirement to carry over hours, but in Los Angeles now there is a 72-hour requirement. And then in San Francisco, they have implemented their own paid sick leave benefit ordinance as well. And saying that you cannot limit the annual use of the sick leave benefits, whereas in California you can limit it to 24 hours or 3 days. And they have a 72-hour cap. which means that once you hit 72 hours, similar to vacation pay, if you hit 72 hours, then they stop accruing until they actually take some sick leave. For federal contractors, which I know we have, again, a couple of people here who do that, the Obama implemented Executive Order 13706, which is going to require federal contractors to provide 7 days of paid sick leave for their employees. Now, the Department of Labor has a deadline to issue their final regulations of September 30, which is in 2 days, but I have not seen anything yet on that, so I'm not sure where that is at this point. But hypothetically, if they do get those final regs out, they are supposed to go into effect on January 1, 2017, and then the federal contractors will need to start providing up to 7 days of paid sick leave. So there's a question about the paid sick leave. For Los Angeles, I understand we have to offer the employee 48 hours of sick time per year. My question is, what is the year date? Is it June 1st when this law went into effect? Well, it went into effect July 1st. So the year could be several different things. It's really up to the employer to decide how they want to define that year. So you could do just July 1st for everybody, or it could be, or it's supposed to be actually the beginning of the calendar year. And so for 2017, you will have to give a total of 48 hours of sick time for 2017. And then another question, if someone carries over 72 hours of sick leave in Los Angeles, do they continue to accrue for the following year? Yes, they do. They do continue to accrue. But you only have to carry over 72 of those hours. So if they continue to accrue and they accrue 100 hours, you don't have to allow them to carry all of those hours over to the following year. And just to let you know, too, for those people who are in San Francisco, there also is an additional poster that needs to be posted that has information about those paid sick leave benefits. And Los Angeles also has this information, which goes hand in hand with the minimum wages. And there is no collective bargaining agreement exception to the paid sick leave benefits. Okay, so now I'm going to talk a little bit about joint employment. There's been a lot of discussion about the new Department of Labor, it's called an administrator's interpretation, but we'll talk about, just say, regulations regarding who is considered a joint employer. And there are two ways that you can have a joint employment. And the Department of Labor talks about this as being horizontal or being vertical. So for horizontal, what that means is that an employee has employment relationships with 2 or more employers, and the employers are sufficiently connected to each other or related to each other with respect to that employee. So for instance, if you own 2 restaurants, you own one in Los Angeles and one in, I don't know, Santa Monica, and you have an employee that works at both of those restaurants, it is possible that those 2 restaurants will be considered joint employers. It also could be, another example could be where you have more than one employer arranged to share workers. So for example, a farm worker who works at 2 different orchards, but the orchards have an arrangement that they share the produce pickers. Those could be considered joint employers. Essentially, that the employer acts directly or indirectly in the interest of another employer. They look at in determining whether there is this horizontal joint employment, they will look at the control factor and whether the employer controls or is controlled by or is under common control with the other employer. So for instance, if you have a security guard protecting a business, if the business has enough control over that employee, they could be considered joint employers. But not all dual employment is joint. So if you have an employee who, say, is a part-time employee and then they have another part-time job, so let's say they're a part-time employee at McDonald's, but they also have another part-time job at Walmart, just because they have two part-time jobs does not mean that McDonald's and Walmart are now joint employers. They're just two separate employments. Now, the other way that you can have joint employment is through what's called a vertical joint employment. And that is where an employee has an employment relationship with one employer, and the economic realities, that's the key word, the economic realities show that the employee is dependent on and therefore employed by another entity involved in the work. So traditionally you would think of this as being like a staffing agency or a subcontractor or a labor provider or some other intermediary type of employer. And what you need to do to determine whether there is joint employment is to look at the economic realities to determine whether the employees are dependent on both of those entities. And there are several factors that are looked at in determining whether there is vertical joint employment. They'll look at whether the intermediary employer is an employee of the potential joint employer. Then all the employees of the intermediary are also employees of the joint employer. So if you have like a employer within there that is hiring employees, then those employees do end up being part of the other employer. They also look at the control or supervision of the work performance, the control of the employment conditions, whether the employer at issue has decisions to hire or fire or set the rates of pay for the employees. They'll look at the permanency or the duration of the relationship. The longer the relationship, the more likely of them being joint employers. But it can depend on the nature of the industry. So if it's a seasonal industry or something, then just because they're only employed for the season will not necessarily help you in avoiding the joint employment situation. They'll also look at the type of work that the employee is performing. If it's repetitive or rote or unskilled, or you need very little training to do it, then the more likely that there's going to be a joint employment relationship. They'll also look at whether the employee is performing work that is integral to the business. So for instance, if you're hiring employees through a temp agency to perform your customer service work versus you're hiring a painter to come paint your walls. Your customer service work, it probably is integral to your company versus the painter who's coming to paint your walls. That's not something that is part of your business per se. They'll also look at whether the work is performed on your premises and whether the premises is owned or controlled by the employer at issue. And whether you're performing administrative functions that are commonly performed by employers. So for instance, if you're handling the payroll, providing workers' comp insurance, providing equipment, things like that. And this kind of goes into Barry's asking how do PEOs fit into the vertical joint employment. Again, it's really going to depend on what the relationship is between the PEO and the employer. You're going to look at that contract and see what duties each are responsible for to see whether you end up in a joint employment situation or not. One of the things that the Department of Labor emphasizes in their new interpretation letter is that you have to look at the particular circumstances of each of each situation. There is no one size fits all. And you don't necessarily, whereas in California we've traditionally just focused on the control aspect, the Department of Labor has made it clear that control is only one factor of many, and you really have to look at the economic realities of whether both entities are integral in the employment. And it's a much broader test than it has been in the past in determining. And so essentially we're going to get to a point where you're basically going to need to assume that you are a joint employer unless you have measures in place to avoid that. So for instance, I have a client who is a security guard company. And they provide security guards to businesses to secure their premises. In order to avoid that joint employment relationship between the security guard and the employer, the security guard company makes it clear that the employer has no control over whether the employee who is hired, who is fired, who is placed there, how much that employee makes, the duties that the security officer is supposed to do, the training, the equipment, the uniforms, all of that stuff is part of the security company, and the employer is hands off. All the employer does is say, I want a security guard to show up here, from 8 to 5. And by putting those measures into place, you can try to avoid the joint employment situation. Now you may be asking yourself, well, why does it matter? Why do I care if I'm considered to be a joint employer? Well, there are several reasons why you should be aware as to what joint employment could put your company at risk for. So one is there are many laws that talk about joint and several liability for employee situations, whether it be harassment, discrimination, wrongful termination. If employers are considered to be joint employers, they could both be liable for unlawful actions taken against the employee. Another issue, and this is more for the horizontal issue, is that the work hours that the employee performs for joint employers are combined. So to take the example of the people at the restaurants, if you have somebody working at your two different restaurants, at one they work 20 hours and at the other one they work 30 hours, if they were independent employers, there would be no overtime at issue. But because they are joint employers, now you take the total, which is 50 hours, and now there's 10 hours of overtime that has to be paid out. So you have to look at those types of issues to see whether there's going to be some implications for overtime. There also could be implications in terms of health benefits and whether they qualify under the ACA as working 30 hours or more. Also, in terms of laws that require you to determine how many employees you have. So, for instance, the Family Medical Leave Act, or CFRA, if you have 50 employees, then within a 75-mile radius, then you fall under those laws. So if you have a joint employment situation, it's possible that you're going to have to count all of those employees to see whether they are entitled to protected leave. And whether you need to engage in interactive processes with those employees. So as you can see, these, as I mentioned before, the joint employment situation with these new regulations, they're possibly, whereas you may have thought that you weren't a joint employer with either your PEO or a temporary agency or some other labor service that you do business with. In the past, you may have not been considered a joint employer, but you may want to relook at those relationships and those contracts that you have with these other companies to see whether under these more expansive factors, whether they could now be considered joint employers, and if so, what you might want to do about that and try and protect your company. Okay. So I'm just going to talk about some other quick things just so you're aware of them. For wage statements, there was a new law that wage statements. Plaintiff lawyers love wage statements and love poring over those wage statements to see if they can find some technical problem with your wage statement and file a class action against your company. So to avoid some of those ridiculous lawsuits, the legislature has helped out employers a little bit to try and cure these defects. So the ones that you can now cure without being held in violation are if that your paycheck stubs do not include the dates of the period for which the employee is paid, or if they do not have the name and address of the legal entity that is the employer. So if your paycheck stubs or wage statements for some reason don't include that information and someone brings it to your attention, you now have 33 days to try and cure those problems. And in order to cure those defects, the employer must show that you have become fully compliant and that you have provided fully compliant itemized wage statements to each employee for the 3-year period prior to the date that you received notice of the violation. In other words, you're going to have to go back and reissue corrected wage statements to employees for every pay period for the past 3 years. So it is a lot of work to make this cure, but in the long run, it is probably cheaper than getting penalized for every single pay period and every single paycheck that was wrong. So you get a little bit of relief there. The other law that went into effect is that the legislature has made clear that the requirement that you provide the total hours worked on a wage statement only applies to your hourly employees, not your exempt employees, since no one keeps track of when their exempt employees are working. And plaintiff lawyers, again, we're trying to make that into a big deal, and the legislature said, yeah, no, we don't think so. There's a question about wage statements and a question about whether if they are available online for employees, are we required to give them a paper copy? No, you are not required to give them a paper copy. However, if they do request a paper copy, you do have to give them the opportunity to ask for a paper copy in case an employee does not have access. They don't have a computer at home or at work that they can access their wage statements, then you do have to give them an opportunity to receive them by paper. Okay, rest breaks. There was a case that came out this year from the 2nd California District where there was a company that was, they were a manufacturing company, and they had this complicated machinery that if you stopped working with the machinery, you would have to shut down the machinery, and it would take time to do that, and it would take time to start up the machinery again. And so this employer actually did not give 10-minute rest breaks for every 4 hours worked. Instead, they combined the rest periods and said, we're going to give you a full 20-minute period instead. And their rationale was that, by the time that 10 minutes comes up, it would take too long to get them back to work and get those machines working again. And in this case, the court said that that was okay. Because there was a legitimate business reason as to why it would not make sense to give employees 2 10-minute breaks during their 8-hour shift, and instead to combine them into 20 minutes. I would caution, though, that this is a very rare circumstance. I would err on the side of caution if you can, and just give the 10-minute rest break periods. But if you have a unique situation at your particular company, it could even just be with a particular employee or a few employees. If there is an issue in terms of the difficulty of giving those 10-minute rest break periods, then you may want to talk to your counsel and see whether there's a legitimate basis to not provide that and to provide it in a different way, such as the 20-minute combined. Hot off the presses, there is a new law that was passed. Governor Brown signed a little while ago, AB 2337, which says, yay, we have another new hire notice that we have to give to everybody. Woohoo, just another thing to add to our packets, to our new hires, that we now are going to have to advise them of their protections for victims of domestic violence, sexual assault, and stalking. The actual notice is supposed to be being created right now by the agency, and once it's created, then we're going to have to start giving those out to our new hires, along with a whole other big stack of papers that we give them.
Sherry?
Yes.
Let me just talk about one other notice. Governor Brown signed Friday a notice about the Earned Income Credit, that starting January 1st, all employers are going to have to provide a notice along with the W-2 forms when they do that in January that says that the employees may qualify for the Earned Income Credit under federal tax laws and also under state tax laws. And I have a model notice of that. We have two more questions, Sherry, that popped up, and we're also bumping up against 11 o'clock. So I said it was an hour, but if we need to go over, Sherry, if you're available, that would be good. And if the participants are willing to stay, that would be okay. But we have two questions. Maybe we have three now. One from Ophelia. Does sick time or PTO have to show on wage statements?
Yes, they do. That's required under the paid sick leave law, that you do have to have it show up on the wage statements, and PTO, yes, needs to show up on wage statements as well. And I see these other questions here. One from Susan, can an employee request one 20-minute break instead of two 10-minute breaks? Well, they can request it, but you're going to have to say no. Under the law, unless there is a legitimate reason to give them just one 20-minute break, you need to authorize and permit and allow them to take those 10-minute breaks.
And in regards to Mark's question about a list of new hire notices, we do provide that list to all of our clients. So, Mark, I can get that to you offline and give you a list of those notices.
Yeah, and I also have, although I'll need to update it for January, I have a nice big laminated list of all the new hire notices and for California as well. So if anyone's interested in that, I'll show you my email address at the end of this, and you can email me and ask for one, and I'm happy to send it to you.
Super, and I'll compare my list to Sherry's list, and hopefully they're the same.
Hopefully.
Okay, so we'll let you move on.
Okay, and then another quick question here, is sick time included in PTO if the PTO exceeds minimum sick day requirements? Yes, you are allowed to use PTO instead of sick leave, but it does need to meet all the requirements for the California sick leave, or if you are in another jurisdiction, you need to also, it needs to comply with the requirements within those jurisdictions. Okay. So I'm going to try and speed it up here a little bit since we are getting towards the end here. Suitable seating requirements. I'm not sure if this is an issue for anybody, so if it is, we can talk offline. But as you probably know, in most wage orders, it requires that people be able to sit when it is reasonably available to do so. And there was a question as to what that means. And the California Supreme Court, in an advisory opinion to the Ninth Circuit, set forth the different factors that you have to look at to determine whether you need to provide somebody a seat. And of course, they have to make it complicated, and it's going to depend on the particular circumstances. You're going to be looking at the nature of the work, and you're also going to be looking at the physical layout of where they're sitting or where they're working and whether they can actually get a seat. And also you can look at the employer's business judgment in determining whether they should have a seat or not. But basically you have to look at the totality of the circumstances to determine whether there should be a seat there or not. So if you do have employees that stand up for, in the retail industry or some other industry where your employees are standing a lot, you may want to look at whether it is practical to be able to provide them a seat. There was a recent case regarding rounding and whether rounding is lawful, and the Ninth Circuit said yes, it is. And this was just sort of a funny case because of the sued over $15 and said that they were unlawfully had $15 taken away from them because of a rounding practice, and the Ninth Circuit said that was fine. E-cigarettes are now banned in the workplace. So if you have a no smoking policy, a written policy, you want to add in e-cigarettes, vaping, etc., that's not allowed in the workplace anymore. The disability compensation is going to be increased starting January 1, 2018. The percentages of salaries that people will get is going higher. This doesn't necessarily affect employers directly. This is disability compensation they get through the state, but it's going to be a better benefit for employees that you can sell to them. And also they're going to get rid of the 7-day waiting period for that. But that's not happening until 2018. For federal contractors, there is the new Fair Play and Safe Workplaces Executive Order. So if you're a federal contractor, you're going to want to look at this. Because of the time constraints here, I'm not going to really go through this because we only have a couple of federal contractors here. But people who are bidding on contracts, pretty high-level contracts, starting October 25 next month, you're going to have reporting requirements in terms of what violations your company has been found to have under different federal laws for the last, and they're going to phase it in over a 3-year period. For this year, I think it's only for a year period or something. And it's only for the federal laws, and whether there's been any violations of those, eventually they're going to bring in the state laws, but they haven't done it yet. Arbitration agreements, this is another one that could be an entire webinar if we wanted to, and it's an ongoing process. I don't know how many of you guys have arbitration agreements right now or whether you're considering arbitration agreements. Back in 2011, there was a key U.S. Supreme Court case that talked about that class action waivers in arbitration agreements are enforceable, and employers cheered, and all of a sudden there was a flurry of arbitration agreements going out. But those have been scaled back a little bit, and there's a question as to how enforceable those arbitration agreements are. So in 2012, the National Labor Relations Board, in a case called D.R. Horton, found that the class action waivers actually are not enforceable under the National Labor Relations Act when it comes to concerted activity regarding their conditions of employment. This was an issue that was not addressed in the Concepcion case back in 2011, and so the NLRB said, well, you didn't look at this, and we think that our policies trump, and therefore you can't stop people from filing class actions because those are considered concerted activity. Since then, a lot of courts have weighed in on whether they like D.R. Horton or not. In 2014, the California Supreme Court in the Iskanian case disregarded D.R. Horton and said that they are enforceable. However, waivers of our Private Attorney General's Act, which all employers just love, those you cannot waive those claims in arbitration agreements, and that's been the law for several years now in California. The federal circuits have been split on the issue of whether Horton applies. Initially, everyone was going the way that the California Supreme Court did and said, no, we're not going to listen to you, NLRB. We're going to follow the U.S. Supreme Court, and that those class action waivers are enforceable. However, a couple months ago, the Seventh Circuit decided to go the other way and said, well, we're actually going to follow D.R. Horton, and we think that they're not enforceable and that the National Labor Relations Act trumps. And then last month, the Ninth Circuit weighed in the Morris versus Ernst & Young case, and also went with the Seventh Circuit and decided that class action waivers are not enforceable. So what does that mean for California employers? We have a California Supreme Court telling us that they are enforceable, and we have a Ninth Circuit federal court telling us they are not enforceable. What will the California courts do? We don't know. They could follow the Supreme Court and say we have to listen to our Supreme Court. They could follow Morris and say this is an interpretation of federal law, and so we need to follow the Ninth Circuit. This is brand new, so we're not sure what's going to happen. What we do know is that there are 3 petitions pending before the U.S. Supreme Court, including the Morris case and the follow-on to D.R. Horton, which was the Murphy Oil case, asking the Supreme Court, the U.S. Supreme Court, to resolve this issue. Which, if they do decide to take it up, which way are they going to go? We don't know. Because we have an empty seat. So we don't know who's going to fill that empty seat on the Supreme Court. So it may ultimately decide on who becomes our president and who they appoint to that seat as to whether these class action waivers are going to continue to be alive or not. The one thing that the Ninth Circuit did say, though, is that these class action waivers are not enforceable when you force them upon the employees. If the employee actually has a choice as to whether to agree to the arbitration agreement, then they're deciding whether they want to engage in that protected activity, and those can be valid. And that's what happened in the recent Uber case, because you might be thinking, well, wait a minute, there was a recent Uber case that enforced this. And because in that case, the individuals had the option of whether they wanted to agree to that arbitration agreement or not, and so that's why they were enforceable. There's some other issues that are sort of percolating around with arbitration agreements, including who decides what is arbitrable. The lesson to be learned there is really that your arbitration agreements need to be very clear as to what is arbitrable, what is not, who decides these issues, and whether it's going to be the court that decides issues, initial issues about the enforcement of the arbitration agreement, or if an arbitrator is going to make those decisions. And there's pros and cons to both of them, and you may want to consult with your counsel to make those types of decisions if you do have arbitration agreements or are thinking of doing that. And there also was a recent California Supreme Court case that said even if you have an arbitration agreement, if you carve out that you can go to court to get a TRO, temporary restraining order, or injunctive relief, that you can go ahead and do that, and that will not render the arbitration agreement unenforceable. Lastly, I just wanted to bring up some things to watch for in the future, things that are coming down the pipeline that haven't, Governor Brown hasn't done yet, and what the federal agencies are doing. There's been a lot of back and forth about the new reporting data requirements that the EEOC is planning to implement. The final regs are not out yet. They were supposed to come out, but then they decided to revise them based on comments that they received, and they did another comment period, and I know that there was a lot of flutter and people opposed and for the different requirements that they're proposing. So we're waiting to see what the EEOC is going to end up with in their final regulations as to what reporting is going to have to be done in the future. Another issue is the California Supreme Court has agreed to take up another question from the Ninth Circuit, this time on de minimis time. On the federal level, if somebody works a minute amount of minutes or something to accomplish something that is difficult to record or difficult to estimate, then you don't have to pay them for that time. The question is whether California allows that as well. The DLSC has always allowed the de minimis doctrine, but we don't know what the California Supreme Court is going to do and whether they're going to say that it is allowed in California or not. There's a few bills sitting on Governor Brown's desk still, and he has a few more days to sign them, so we'll see what happens and whether he's going to sign them or not. There are two bills pending before him regarding salary history and whether you can base current pay on what prior salary history people have, and whether that is considered discriminatory if you base it on prior salary history, and also whether they're going to expand the Equal Pay Act, the new act that came into play last year, whether it's going to expand to race and ethnicity along with gender. Another one that's before him is SB 654, which is the new Parent Leave Act. Employers with 20 or more employees might be required to give 6 weeks of baby bonding. So this will be sort of a mini CFRA leave for smaller employers that have 20 or more employees, and that would go into effect on January 1, 2018. Another one is SB 1001, which would prohibit employers from requiring more work authorization documents than is required under federal law when somebody is being hired, and refusing to accept documents that look reasonably genuine. SB 1167 has to do with creating some standards for heat, illness, and injury prevention for indoor workers. We have prevention standards for outdoor workers, but they are looking to expand that to indoor workers as well, and have OSHA create some standards for heat, illness, and injury for those individuals. And finally, SB 1234, they're looking at whether to create a retirement savings plan for employees excuse me, for whose employers do not actually offer retirement plans, 401k plans, or similar plans to their employees. So we'll see what Governor Brown does with that one. With that, that's everything I've got for you today. Sorry I sort of sped through the last part of it. But again, if you have any questions, I'll stay on the line for a few more minutes if anybody has some questions. Or if you have a complicated question that you want to talk to me offline about, feel free to email me at shavit@tharp-howell.com, and I'll be happy to talk to you offline.
Sherry, on behalf of Really Great Employee Benefits and everyone on the webinar today, I want to thank you very much. This was an outstanding webinar on an update on labor laws that affect all of our clients, and just wanted to thank you and let everybody know online that we have recorded it. We will be sending it out to everybody so they have something to look at and hear if they want to do that again. And we'll be having another webinar next month, most probably on ERISA and HIPAA compliance, updates on that. Sherry, if anybody has any questions, it's all up to you.
Well, I don't really see any questions coming up here, but I do want to thank everybody for listening, and thank Barry as well for inviting me to do this webinar. It was my pleasure. Barry, there's a question about how they'll get the PowerPoint. Are you sending that out as well?
Yeah, Richard, I'll send out the PowerPoint as a PDF, but the PowerPoint should be in the recorded one also, but I'll send it out as a separate item in addition.
Well, thanks very much, everyone. Thank you for your questions and for listening. I hope that you were able to learn a few things today.
Super. Thank you very much.
Bye-bye, everybody.